Welcome everyone to today's webinar, Adult Use Marijuana Has Arrived, Employer Obligations and Compliance Issues, presented by Barclay Damon. Many thanks to our presenters, Michael Schiatti and Chris Harrigan, for being with us today, and all the participants who have joined in. We'd also like to thank our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share what we learn with the business community. Everyone on the webinar today and who's registered will receive a link to that recording later. Michael and Chris will share their presentation with you, then follow with time for questions and discussion. Please use the chat to submit any questions during the presentation. And just a reminder, when others are speaking, to please keep your audio on mute to minimize background noise. With that said, I'll kick things over to Mike to start things off.
Great. Good morning, everyone. I'm Michael Schiatti from Barclay Damon. Myself and my colleague, Christopher Harrigan, are your presenters today. We do have a lot of information to present to you. You have a lot to think about after this presentation here, and we actually think there will be regulations forthcoming relative to some of the things that we're going to talk about here today. But we thought you needed to hear this sooner rather than later, especially because some of the things that used to be criminal are no longer criminal. And you know, like your employees can now legally possess marijuana and walk around the street with it in their pocket, and it's not a crime. They're not going to be waiting for the first adult use shop to open to sell. They can go to Massachusetts, buy it, come back, or just go to their illegal pot dealer and get it, and then they possess it, and it's sort of going to be legal. So we're going to have to deal with some of these issues now. So we've developed here, a very comprehensive PowerPoint. It does not answer every question. Feel free to ask questions throughout as you think about them. What Chris and I have been doing is taking the questions at the end. We have found that easier in this presentation, given that we have so much to cover. But please ask it when you think of it. And that way we'll get to it at the end. So the questions so far that we've been getting doing this presentation have been awesome. And quite frankly, there are gray areas, and some of it is you have to drill down to sort of get the answer and what have you. So let's go see what we got here and go through it. Both my contact information, my Twitter, my LinkedIn, feel free to join me, are here. And Chris's contact information is here. If you think of something in a day or so and you want to ask it and it's a general question, feel free to follow up with us. If it's the 2-page typed email, alleged hypothetical, we know better. It's not a hypothetical, and that's legal guidance. We have a fine line between, answering questions and giving legal advice. So we have to be cautious of what we say and how we say it to you. But we're free to answer general questions throughout. Our agenda today. We're going to talk about the Marijuana Regulation and Taxation Act. Not every nook and cranny of it, because a lot of it has to do with, licensing for dispensaries. That's not what we're doing. We're trying to talk about the impact on employers and things you need to watch out for. That's our approach here on this. Our firm is putting on podcasts on every aspect of the law. I think we've already done 6 or 7. So if you want detailed information, shoot me an email or Chris an email. We'll just send you the link to the podcasts in that regard. It is on LinkedIn as well. We're going to give you a general overview of the law. We're going to specifically talk about some of the adult use or recreational rules that you as employers are now going to have to deal with in the great state of New York. The medical program will be expanding, as Chris will explain to you. Now we're also going to deal with the expungement of certain criminal convictions, which I will explain to you. And this is those of you that ask the magic question, which we think you should. Have you ever been convicted of a crime? You now may get a negative answer And if you also background check, and the employee is being truthful because the record has been expunged in that regard, the background check may not catch up with it. And so you may have a contradictory answer from the applicant versus the background check, and we're going to have to talk a little bit about how to deal with that because certain things are going to be expunged from criminal records. So we're going to walk you through Article 23A of the New York State correction law in that regard. Some of you are already familiar with that, and we'll talk generally about the rules there because it is going to be impacted by this law. Then we'll get into some of the more nuts and bolts of the law. Chris will address the amendments to the recreational activities law that basically make marijuana use outside of work a protected recreational activity. I will address some drug testing issues. Please note, a drug test is not a drug test. They're all different, and employers need to realize that. Unless you fall into a couple of the exceptions that Chris will address under the labor law that allows for continued testing of THC, we are recommending to employers not to test for THC. Why? Because the recreational activities law clearly indicates, if you're going to take a employment action based solely on the outside recreational use of marijuana, it's going to be illegal. That's why. And there is no breathalyzer that exists that would allow you to test an employee in the workplace to determine whether they are under the influence of THC. It's in development, and it'll be great when it gets here because that'll be something else that we can use to sort of figure out whether someone's impaired. We have the chamber sent out the materials. There is this reasonable suspicion checklist. Please print this out. We're going to go through it later in the presentation. It's important because I'm going to go through the law that Chris will discuss talks about specific articulable symptoms, but they don't tell us what those are, as Chris will indicate. We'll give you our spin on it in that regard. The Americans with Disabilities Act comes into play on drug use in that regard. Don't be afraid of this law. It is on your side. Both Chris and I will go through the ins and outs of the ADA as it relates to drug use. Believe it or not, the rules are pretty clear. We have to modify them now, given the basically protected status of off-duty THC use. Lastly, we'll end with employee handbooks, discipline, supervisory training. We'll tell you some things that you should consider adding to your employee handbook. One of the things we make it like alcohol. I agree. Can't possess, can't come to work under the influence, can't use. Also make it like smoking. Can't come to work smelling like cigarettes, can't come to work smelling like marijuana. So we'll go through some of those rules for you in that regard. Attached with the reasonable suspicion checklist, which I've already mentioned, we've also attached the New York State Correction Law, Article 23A employment poster. This needs to be posted in your workplace. And if you do background checks on any of your employees, a copy of this needs to be provided to them when they sign the authorization for the background check. Is this the new normal? I hate to say, if this is your employee and they are outside of work, the answer is yes. This is the new normal, and there's not going to be anything you're really going to be able to do about it if it's off-duty activity, not on your property, not using your equipment. Can they come to influence under the influence of THC at work? No. Can they bring those glasses into work? If you have a well-crafted rule in place, the answer is no. Can I prohibit drug paraphernalia? Sure. And other things like that we're going to talk to you about. So with that, I'm going to turn it over to Chris to give you some of the more in-depth information in broad strokes on the law. Chris?
Thanks, Mike. Good morning, everybody. Thanks for joining us. So I'm going to go through quickly just a general overview of the Marijuana Regulation and Taxation Act, which I commonly refer to as the MRTA. March 31st, the governor signed this into law. It was a long time coming. Some provisions are effective immediately, things that Mike already talked about, like being able to walk around with a certain amount of cannabis, marijuana in your pocket, being able to do some things at home, and being able to consume it without repercussions or threat of criminal prosecution. Those things, among other things, as well as what I'm going to talk about a little bit later in the presentation regarding the recreational activities law and how the legal use of cannabis is now included under a recreational activity. Those things are effective now. There's some other things that are going to be effective down the road. Things like how to apply for a license, the setup in respect to the retail dispensaries, and some other. There's a lot of volume and breadth to this, to the MRTA, and a lot of the stuff. It hasn't been. The regulations haven't been set up. The rules haven't been set up. Applications haven't been created, let alone processed. So much of what's contained in the MRTA will be down the road, but there's a lot of important stuff that you all on the call need to know about now that we'll talk about today. So just generally speaking, and I'm sure you've read all this or heard about it on the news, this law permits adults over 21 to purchase cannabis for recreational use, possess it as well. It allows for limited home growing. Most importantly, in the way that this was sold to a lot of legislators and that voted for it and got support for people in the public, was it creates, theoretically, assuming that the sales are there, significant income streams for education, drug treatment programs, and then state and local governments. The MRTA establishes the Office of Cannabis Management, and this office is going to be a subdivision of the Liquor Authority. And same kind of regulatory setup. For those of you that are familiar with the Liquor Authority, there's going to be different directors and officials that are appointed, some by the governor, some by others, in respect to this office, and it will oversee all things cannabis, whether it is enforcement of regulations, processing of applications, decisions in terms of who's going to be licensed. All those things will be covered by this office. In addition, what the MRTA does is it expands the current New York medical marijuana program. And that's important for a lot of reasons. It's going to allow for, and you'll see it in a couple slides, some new and different and expanded abilities for those that have medical marijuana licenses and those who also have medical marijuana cards. As Mike discussed, and he'll discuss some more in detail in his later slides, this also provides for the expungement of criminal records, which is going to have a significant effect in regard to background checks, in regard to criminal conviction inquiries, and then so that's important to know about. It's also going to be important that you think about and you remember that, notwithstanding this law as it relates to expungement of criminal records, there's some local laws as well that you got to keep an eye on. Both Buffalo, Rochester, Syracuse, and New York City all have local laws in regard to the timing of being able to ask about criminal convictions in connection with a job offer. So just need to be cognizant of that going forward. So there's a licensing system that I mentioned. That licensing system is going to be it's going to be interesting in the next year when they set it up, and there's a lot of nuance to that licensing system in terms of who can apply, certain quotas they have in respect to who can receive the license, the point system, and what's going to get you more points, et cetera, et cetera. So we don't know what all the rules are yet because they haven't established them. They're in the process of getting those finalized, and once they are, it'll be it'll be, they anticipate that the volume of license applications will be as great as anything they've seen in a long time in the state of New York. The MRTA, in this regard, it creates social and economic equity programs. So more specifically, applicants who are people of color, certain denominated minorities as set forth in the statute, women-owned businesses, places that are going to be established in certain area codes which are considered economically disadvantaged, they will have an advantage, and they are committed to granting a certain number of those license applications to those applicants who check many of those boxes. So that will be that'll be a big issue when this thing gets rolled out in earnest in terms of the application process. So it's big business, as we all know. The state is estimating that it's going to be $350 million in annual tax revenue. Let's hope that's the case. Certainly, New York State could use the money. In addition, the state estimates that this is going to create 30 to 60,000 new jobs in the state of New York. It's a lot of jobs, and remember, it's not just your corner weed store, right? You've got grow centers and distributors and new medical marijuana facilities, all of which will be highly regulated, all of which are going to be separate entities. And there's, as Mike and I were discussing yesterday offline, that there's all the players. You've got everybody from, Joe and Jane Smith who decide they want to take their money and make a run at an application because they want to get started in a new business, to the biggest companies in America, places, things like, Coca-Cola, Big Tobacco. Everybody's getting in on this game and wants a piece of the action. There's no surprise in respect to the MRTA. Again, it was inevitable in the state of New York. It's big money. We are surrounded by states that have either already legalized adult use or are in the process of getting they have legalized it or are in the process of getting their dispensaries up and running. I think a lot of us are familiar with Massachusetts and the fact that people make their runs to the border to go get recreational marijuana in Lee and other places. New Jersey has recently enacted a new statute, and their dispensaries will be open shortly. I know Pennsylvania is also, in the midst of everything right now. So not a surprise. The state doesn't want to continue to lose potential tax revenue to neighboring states and wants to cash in on this as well. And then, as I mentioned, there's the Compassionate Care Act, which is the medical marijuana law, and that sunsets in July of this year. So they need to expand that. They need to get that renewed, and we'll talk about that a little bit later. And more specifically, so it's July that it expires. It was enacted in 2014. Just to give you an idea of the growth of medical marijuana in the state of New York, and I think the state is hoping that the growth of medical marijuana is somehow indicative of how recreational marijuana will be received and will grow now that it's legal. So in January of 2017, the state had 816 healthcare providers that were registered for the medical marijuana program. A little bit over 4 years later, that number jumped from 816 to 3,204 providers. So as you can see, it's a huge jump. And then likewise, in January 2017, there were 12,000 and change patients that were certified by some healthcare professional to receive medical marijuana 4 years ago. 4 years later, that number has grown more than 10 times. It's almost 150,000 people. I mean, that's just it's an incredible jump. Again, I think the state is hoping that it's indicative somehow of not only the growth of medical marijuana and why they want to expand this to go beyond the sunset, but also the hope is that recreational marijuana will grow in a certain fashion that will lead to additional tax dollars. So in terms of the program itself, as I mentioned, there's going to be more conditions that allow you to qualify whether it's your existing condition or some other ailment that you may have. They're going to open that up a little bit so it's easier for people to get a medical marijuana card. The number of caregivers are going to increase. There's going to be tremendous more offerings of the types of medical cannabis that a patient can go out and can choose from and purchase. And then there's also going to be some home cultivation, which will be highly regulated, but they're going to allow it. All very interesting, and it includes a lot. We're going to drill down on some of the most important things this morning as it relates to you all as employers. And with that, I'm going to turn it back over to Mike, who's going to begin talking about criminal convictions in Article 23A. Mike.
Thanks, Chris. So we tried to set this up, to give you the compliance issues that you're going to have to deal with, so you can talk to your supervisors. If they see Johnny smoking a joint on Facebook Live and it's Saturday afternoon, not much they're going to be able to do about it. The first issue we want to talk to you about is what criminal records are being expunged, the concept of the background check and the criminal conviction inquiry. A lot of you have probably got individuals who have had drug-related criminal convictions. And my guess is for most of you, you probably said, no, we're not going to hire, but we want to go through and remind you what the requirements are. Many employers get this wrong. There are a couple former felons and guests of the state of New York that make their living going after employers for violation of Article 23A. Both Chris and myself have dealt with these individuals, and literally they make a living in that regard. And one of them has wrote a book for individuals on basically how to come after you in that regard. So it's key that you get this correct. Let's start with what is no longer criminal. Personal possession outside of the home, up to 3 ounces of cannabis and up to 24 grams of cannabis concentrate. Home possession is going to be permitted in the home, but you basically have to keep it under a lock and key and away from children. And remember what Chris said, 21 and older, the law is going to protect in that regard. Home growing is going to be allowed 18 months after the first adult use sales occur in New York. And the rules will be each individual over 21 in the household can have 3 mature plants and 3 immature plants as long as they're over 21. They've also put in place a cap for the entire household. So the cap is 6 mature plants and 6 immature plants, the maximum in that regard. So if you have 3 individuals over 21, it is not 9 mature plants and 9 immature plants. It's going to go to the cap of 6 mature and 6 immature in that regard. And those are the records that are being expunged by the state of New York. So if I have a conviction for possession, and it meets the requirements of the new law, that will now be expunged. I probably won't have that misdemeanor conviction. I'll be able to answer the question that you posed. Have you ever been convicted of a crime? No, assuming that I don't have any other criminal convictions. This is going to come up potentially because the background check might be wrong. I'm not saying it will be. It might be wrong, because maybe the records simply haven't been updated yet in that regard. So there could be a conflict that you see between the background check and if you ask the magic question, have you ever been convicted of a crime? Now let's start from a compliance perspective. Chris has mentioned we have local laws, Syracuse, Rochester, Buffalo, New York City. Some counties have criminal conviction inquiry bans. When you drill down on those bans, what they basically say is you can't ask it right away. And one of the things that we recommend to employers is that you give a conditional offer of employment. And then what is it conditioned on? A background check, you completing a criminal conviction inquiry form. Maybe you got to get a physical. Maybe you have to submit some documentation such as proof of education and a copy of your diploma and things like that. So do a conditional offer and then do both. I think you're free to do both, the background check and the criminal conviction inquiries. And I see conflicts between the two quite a bit in that regard. So one of the things we're going to walk you through is the criminal conviction inquiry rules under Article 23A. Let's start with the human rights law provision that basically says, hey, it's illegal to discriminate against someone based on their criminal record. So the policy of the state of New York is give them a break. Let's not discriminate against them. However, there are exceptions. There is always going to be exceptions where there is a direct relationship between one or more of the previous criminal offenses and the specific employment being sought. So the example I always like to give there, and I actually had this years ago when I was a young attorney, the firm I worked at accepted walk-ins. And I'll never forget two of the walk-ins, and I'm only going to tell you the story of the one. The one guy came in, and I didn't know it was a cold thing, just came off the street. I've been discriminated against by what was then Marine Midland Bank. I said, well, how have you been discriminated against? They won't hire me as a security guard because of my criminal conviction. And first he tried to tell me, well, I was really innocent. And I said, I don't care, you got a conviction. And I said, oh, by the way, did you go to prison? He's like, yeah, I went to prison for 7 years. And I said, what was the conviction for? And he's like, bank robbery. So think about it. He was a convicted bank robber and wanted to work as a security guard in the bank. Yeah, that's not happening. That is clearly one of the exceptions. The granting or continuation of employment would involve an unreasonable risk to property or the safety or welfare of specific individuals or the general public. Sometimes you get individuals who are on the sex offender registry and they have certain criminal convictions. And we run an analysis, are minors going to be in the workplace frequently? How about a candy shop in that regard? How about like a toy store? The answer is probably we're not going to hire him based on this exception. So just keep in mind the exceptions. Now, we typically see employers get in trouble in the area of drug convictions and any convictions. They don't consider all the factors. If you are going to deny employment to someone based on their criminal conviction, you have to consider all of these factors. You can't simply sit there and say, he's a felon, I don't want to hire him. That is illegal. Now, some of you are in highly regulated industries, such that the state of New York does the background check. The state of New York tells you whether you can or cannot hire this individual. That all stays the same here. That is not what I'm talking about. I'm talking about the rest of you who are not in this area. So here's the factors. Number one, the policy of the state of New York not to discriminate against individuals with criminal records. What are the specific duties and responsibilities of the employment the individual is seeking? What bearing does the criminal conviction have on their ability or fitness to perform the job? How much time has elapsed since the occurrence of the criminal offense? And the next one, what was the age of the person at the time of the criminal offense? So we're not asking what their date of birth is, but we're allowed to ask, how old were you when you committed an axe murder? You were an axe murderer, or whatever the case may be. And they have to tell you, yeah, you can sort of back into their age, but you're going to get some idea how old they are if this comes up. But most employers really care less about age. The seriousness of the offense was the example I always give is the individual was 18 years old, on spring break, highly intoxicated, and was caught peeing on the beach. It was a misdemeanor. he pled guilty thinking it was no big deal. Turns out it was a criminal conviction. Compare that to a child molester, a rapist, or a murderer, and everything in between. The other thing you must consider is any information the employee produces relative to rehabilitation. Do they have a letter from their rabbi? Do they have a letter from their priest, a letter from their doctor or drug counselor? You have to consider that. Many employers reject it, saying, we don't care. You have to care. Certificates of good conduct, certificates of release from disabilities also have to be considered. And lastly, the legitimate interest in protecting the public and specific individuals in that regard. These 8 factors many employers overlook in that regard. If you get a certificate of good conduct or certificate of relief from disabilities, those items create presumptions that the employee, or the applicant, I should say, has rehabilitated. And so basically it's like, don't hold the conviction against them. No one factor controls. You're going to have to, if you're denying employment to someone based on a criminal conviction, you're going to have to document it. And I'm going to explain why in a second, because you may be asked by the convict, why did you not hire me? And you're going to have to answer. Make sure you review job applications, the questions your managers are asking applicants. If they ask the question too soon and you're in one of those cities that myself and Chris mentioned, you could be in violation of a local law in that regard. I already mentioned this. One of the attachments is the Article 23A poster. If you do background checks, you have to give them a copy of that when they sign the authorization. Here's why you may have to document. This is highly unusual in employment law. Let's start with your law-abiding citizen. If your law-abiding citizen applies for a job with you and you don't give it to him, do you have to tell him why? The answer is no, you don't. How about the individual with a criminal record? The answer is yes, you do, and here is why. An inmate, a convict, applicant who is denied employment can verbally or in writing ask you, why was I not hired? You must answer. You must answer in writing, and you have 30 days to do so. That is something that counsel writes for you. That is not something I want you writing yourself. Just realize this. This is an oddity in employment law, but it is out there. Also, please remember to comply with the federal and state Fair Credit Reporting Acts and compliance relative to background checks. I'm now going to walk you through the criminal conviction inquiry. This is something that you should ask applicants after you've given a conditional offer of employment, saying, we're going to talk about your criminal record. Have you ever been convicted of a crime? Yes, no, not sure. If this is an online application, they're going to have to check one. If this is a paper application, let's talk about some things that these individuals do. They put the circle between the yes and the no. They skip it and don't answer it. Or they say, not sure. Make them fix it, number one. And if they're not sure, say, well, go figure it out. And when you're done figuring it out, come on back and we'll see if we still have a job for you and you can continue with this process. The criminal conviction inquiry form should give you an explanation of the question, a disclaimer, basically we don't discriminate, and what is the impact of the failure to disclose, i.e. what if you lie to us on this form. Here's what the explanation of what is a crime. Some of you I've done this for in the past, we have added, or the conviction was expunged in that regard. So put that, make that explanation in there now that we have the new marijuana law and the expungement of certain criminal records. Here is the disclaimer. We don't discriminate on the basis of a criminal record in that regard. What is the failure to disclose? Basically, if you fail to disclose a criminal conviction, we're going to hold it against you in that regard. Okay, so the questions continue. For each criminal conviction, we're going to ask first, how many criminal convictions do you have? For each, if you have more than one, who they're going to contact, because they're going to need more paper probably to complete it. We want to know as much detail as possible and make them put in writing more than the criminal conviction. What did you do, genius? I want to know. I want to know, is it a felony or a misdemeanor? I want to know what court the conviction occurred in, when the conviction occurred, how old you were at the time of the criminal conviction, and do you have information of rehabilitation, yes or no? And is there other information you would like us to consider and give it to us? Do you have a certificate of relief from disabilities, yes or no? Produce a copy. Do you have a certificate of good conduct, yes or no? Produce a copy. And is there anything else you really want us to know? So one of the things, when they're telling you the detail of the crime, we actually had this happen. I violated penal law section 175.2A. Does anyone know what that is? I didn't. I had to go look it up. And when I went and looked it up, after, of course, the employer hired the person and then realized they had a problem, it was voluntary manslaughter. And when we looked into the details, we hired a PI to go get the records out of the courthouse and the police precinct down in New York City. The guy and his buddy took turns holding someone down and stabbing them. It was pretty gruesome. And apparently there was some type of plea deal made because some people didn't want to testify, but it was a pretty gruesome thing. If you get something like that, do the drill down. So, and find out what it was they're convicted of. Very serious questions, big implications. Make sure you understand what I just went over. With that, I'll turn it back to Chris, who's going to talk to you about the recreational activities law.
Thanks, Mike. So one of the biggest things that the MRTA did was made some significant changes to what's commonly known as the recreational activities law in New York State. We're going to go through those changes, and we're going to go through some important exceptions that will affect everybody. But before we do that, we're going to just give you a little background on the law and talk about the scope of what it includes. Some of you may be familiar with this, some of you may not. So let's get started. So there's certain types of activities that are covered under the recreational activities law. The first is political activities. Whether you're running for office, campaigning for office, raising money, if you're engaged in political activities, that's deemed protected under 201D of the labor law. In other words, if I'm somebody who loves Donald Trump, but or somebody who hates Donald Trump, and I post these things on my social media, I engage in email correspondence, or you as the employer are otherwise made aware of somebody's political activities and you don't agree with them, it's illegal for you as the employer to discipline, to discharge, or to refuse to hire somebody in that regard. So recreational activities, those are political activities. Recreational activities means it's got to be lawful, and it's leisure time activity, and it's during a period of time in which the employee receives no compensation, and it's recreational purposes. So we're talking about things like sports, hobbies, exercising, reading, television, going to movies. Those types of things are also deemed to be protected, recreational activity. One of the questions that always comes up is, what is working hours? What does that mean in the context of the recreational activities law? So specifically, it means work hours means all time that you're there, including paid and unpaid breaks and meal periods, that the employee is permitted or expected to be engaged in work and all time that the employee is actually engaged in work. So it's important to note that it's only during, it's everything that's after work hours that's recreational activity. Things that occur during work hours are not necessarily recreational activity or not covered by the recreational activities law. So again, prohibitions, as I mentioned, that unless it's an exception or otherwise prohibited, employers can't refuse to hire, refuse to license or discharge or discipline an employee because of a certain number of things, whether it's their political activities outside of work hours that occurs off the employer's premises and without the use of an employer's equipment or other property. So in other words, you can't use necessarily the company car to go driving down the street with your favorite controversial, whether it's political activity or recreational activity that might be something that's objectionable. You can't do it necessarily in the company car, but if it's on your own time with your own equipment and off the company property, if it's protected, there's nothing the employer can do about it. Other prohibitions include the legal use of consumable products prior to the beginning of work hours or after the conclusion of work hours. And again, it's got to be off the premises and without the use of employer's equipment or other property. This is where the big change occurred, and I'm going to walk you through that, but this is where the big change occurred pursuant to the MRTA, where cannabis was included as a consumable product under the law. There's two additional prohibitions. Somebody's recreational activities, that we described before, sports, working out, what you read, where you go to the movies, what you see, that's also all protected, as is union membership. If somebody is a member of a union or is engaged with a union, unless you want to get in trouble with the National Labor Relations Board or the state of New York, it's wise to not discipline, discharge, or refuse to hire on that basis. So there's no protections, though. However, there's no protections if what the activity that's engaged in is going to be a conflict of interest for the company. It's going to put the company in a negative light. If it's going to be somehow negatively affect proprietary information, trade secrets of the company, that's not protected at all. And also, an employer is not in violation of the recreational activities law if action is taken where the employer thinks that, hey, there's a statute that I'm following, and if I don't discipline, discharge, or refuse to hire based on this recreational activity, I'm going to be in violation of a statute. That's an exception, generally speaking, under the recreational activities law. In addition, and there's also no protection where there's if the company has a permissible substance abuse or alcohol program, or there's some other types of requirements pursuant to a contract or collective bargaining agreement, then it's okay to discipline, discharge, refuse to hire, and not run afoul of recreational activities. Another exception, generally speaking, is that the individual's actions are deemed to be illegal or constitute poor performance and proprietary incompetency or misconduct. Where these things occur, again, it's another exception to being able to discipline, discharge, refuse to hire, and not run afoul of recreational activities. So let's talk about it specifically as it relates to the MRTA. So what the MRTA did is it includes it includes possession or use of marijuana while outside the workplace. And again, that magic language that we've talked about before is that the legal usage has got to occur prior to the beginning or after the conclusion of the employee's work hours, off the premises, and without the use of the employer's equipment or other property. So in addition, MRTA provides, and this is how it loops everything. It's language taken right from the act that amends the recreational activities law, and it's amended in part as follows. It states that an employer shall adhere to policies regarding cannabis use in accordance with the recreational activities law. And in this regard, no employees shall be subject to disciplinary action by a business solely for conduct permitted under the MRTA. So in other words, if somebody is using marijuana, like Mike used the example, they're smoking a joint on Facebook Live, you can't terminate them for that in and of itself. There's some additional amendments to 201D that the MRTA established. We're not going to get into those right now because this is the most important thing. So in other words, it's taken the legal use of marijuana, it's made it legal, and said, oh, by the way, the legal use, this is now included. This is now included as protected activity under the recreational activities law. So you might say to me, well, geez, Harrigan, what does that mean? Does that mean now people can go, I got a workplace where I got a lot of stuff going on. I've got, I want to run a drug-free place. You're telling me that I can have people using all the time and high as a kite on my workplace, and this is going to be the new normal? No, that's not what I'm saying. So let's talk about the exceptions because they are important, and they're going to touch a lot of you, if not all of you, in one way, shape, or form. So there's 3 exceptions. The first 2 are related to rules and regulations, whether it's state or federal laws, rules, regulations, federal contracting requirements, or receipt of federal funds. So again, just so we're talking about the exception, it's okay. Employers can continue to take disciplinary action against an employee who engages in off-duty cannabis use where, number one, the employer's actions were required by state or federal statute, regulation, ordinance, or other state or federal governmental mandate, okay? So in other words, and this is the classic example that we've been using. If you, the employer, employ drivers that are subject to federal DOT regulations, and those DOT regulations require drug testing and refusal to hire, discipline, or discharge in the event of a positive THC test, that's an exception. You can continue and should and shall continue to discipline, discharge, refuse to hire where somebody is either known to have used THC or test positive for THC. That's exception number 1. Now, Mike and I are likely going to do another webinar at some point down the road that talks about the nuance of whether it's the DOT example that I just used or some other things that we're going to talk about in the next slide that relates to what your requirements are as it relates to federal contracts, federal funding, and who falls under DOT. How does this relate to other drivers? We could talk for several more hours about that this morning, and we're not going to. Also, some of it's gray. So we've done some research, and we're going to be presenting again down the road on that specific issue, but this is exception number 1. Exception number 2. So exception number 2 is if the employer's actions, and what I mean by employer's actions is, again, refusing to hire, terminating, or disciplining. So if the employer's actions would require the employer to commit an act that would cause the employer to be in violation of federal law or would result in the loss of a federal contract or federal funding. Well, that's a mouthful. Let's just pick that apart for a minute. So in other words, if you are an employer and somebody you have a drug testing policy and somebody tests positive for THC and you have a federal contract or you receive federal funding and a requirement, a term of the federal contract that you have or a requirement of the receipt of the federal refunding that you receive is that you shall maintain a drug-free workplace and you should test, and anybody found to have consumed needs to be disciplined or discharged. If you not doing that, if you deciding I'm not going to test for this anymore, I'm not going to discipline, I'm not going to discharge, when I know somebody's using THC or they test positive, if that decision puts you in breach of the federal contract and causes you to potentially lose that contract, or it makes you ineligible for the receipt of federal funding, that's another exception. You don't have to ignore these things. You can continue to discipline and you can continue to discharge. So in respect to both of those, and we'll talk about this in a minute, it's important to understand what your requirements are. But it's also important to realize this. You got to know specifically what your requirements are, because what you can't do is you can't say, you know what, we want to have a drug-free workplace. And I've read everywhere that even though the state of New York has made adult use cannabis legal, I still know that it's on Schedule 1 on the federal level. I'm going with federal law, and you know, we're going to hang our head on that. Nothing's changed. You know, you use marijuana and we know about it through a drug test or something you post on Facebook, you're fired. You can't do that. You cannot hang your hat on that. Does not allow employers to discriminate against legal cannabis solely because cannabis remains legal under federal law. Has to be more narrow than that. Important to understand. You know, again, legally mandated drug testing for marijuana, under the exception which we talked about above, they can continue. So, you know, some examples are if you got Department of Defense employees or nuclear regulatory positions, of course they can continue to be drug tested because it's going to fall into one of those two exceptions that we talked about previously. So again, review your requirements. If you've got federal contracts, you've got federal grants, understand the terms. You know, it's also not enough to say, oh, I've got federal contracts, I don't have to worry about this. Or, yeah, I receive federal money. Not enough. We've got to understand what are the terms of those contracts? What are the terms of the receipt of the money, receipt of the grant money? Does it require you to maintain a drug-free workplace, conduct and testing, and discipline and discharge when somebody tests positive under a THC drug screen? Important to know. So the third exception is what I refer to as the impairment exception, okay? So again, the MRTA says that employers can continue to discipline and can continue to discharge for off-duty cannabis use where the employee is impaired by the use of cannabis. And what does that mean? It means that the employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of the employee's job position. And then it goes on to talk about, or such specific articulable symptoms interface with the employee's obligation to provide safe and healthy workplace, free from recognized hazards, as required by state and federal occupational safety and health law, okay? So again, as Mike mentioned, and we're going to talk about in a minute, they don't do us any favors in defining what specific articulable symptoms are, but we can figure it out. And we anticipate that there's going to be additional rules and guidance and regulations that do define what those specific articulable symptoms are. Regardless, until that occurs, document everything, okay? And now is a great time because of this change in the law to train supervisors how to document not only about this issue in respect to cannabis, but also all issues. It's after the first of the year. You may or may not have done some training. If you haven't, you can get this all in now, and this is a great reason why. You can use it as an excuse. And if you have, you might want to think about having some further training now that this new law is on the books and it's effective. So in terms of what does that mean, specific articulable symptoms, so we've got the one attachment that's going to have the checklist, and what it really talks about are things that we all know already. Objective signals, bloodshot eyes, poor muscle coordination, lack of concentration, delayed reaction time, you know, all those types of things, those are objective symptoms. So somebody comes in reeking like marijuana and they're falling asleep at their desk, or reeking like marijuana and they're very slow reaction time on the production line. Those kinds of things, along with, and Mike's going to talk about this a little bit later, asking the person, hey, you all right? Are you high? What are you on? Those are the types of things that you can engage in that sort of inquiry, and that coupled with these objective observations, that's another exception that will allow you to discipline and discharge without running afoul of the recreational activities law. So again, as this becomes more commonplace, it's going to be important in respect to the discipline process. And again, depending on what your policies and your practices are, you got to discipline. And that can, whether it's verbal warning, whether it's a written warning, suspending without pay, counseling, termination. If you've got a progressive policy, make sure you follow the steps. If you don't, make sure you measure twice and cut once before you do anything drastic. But document everything, and there's going to be options to discipline that are out there that we should all follow. And something that Mike and I say all the time, and I'll say it here before I turn it back over to Mike, is put it in writing, because if it's not in writing, it did not occur. With that, I'm going to turn it back over to Mike, who's now going to talk about some drug testing issues before we get into the ADA.
Great, thanks, Chris. Just a few other points, just following up on Chris. When Chris was talking about the grants and funding, the first thing you will hear from us is, where are your documents? Where's your contract? Where's your grant conditions? And we are finding a consistent problem with you as employers, not necessarily you, but they don't know. And that's a problem. We need those first of all. The DOT rules that Chris mentioned, we've been getting a lot of DOT questions. Also cover the following, in addition to the drivers: pilots, school bus drivers, train engineers, subway operators, aircraft maintenance personnel, transit security guards that carry firearms, ship captains, and pipeline emergency response personnel. The other thing we've been getting questions on are these, I have a CDL driver, am I covered? The U.S. Department of Transportation has a decision tree. It's basically going to prompt you with a series of questions. I just found it yesterday afternoon, and it will walk you through based on the information you provide. Yes, you're covered. No, you're not. I can't say with 100% certainty it's foolproof, but if you're looking for a quick and dirty answer, that's possibly one way to get it. Chris also mentioned ask them directly, are you high? We recently had a case where the receptionist went outside at lunch, smoked a joint in her car, came back in smelling like pot. And we get the call, and I said, well, go ask her. I said, just ask her bluntly. Yes, I was smoking a joint, but I have a medical marijuana card. Well, one has nothing to do with the other, because if you get medical marijuana, they don't give it to you in smokable form currently in New York. So, and then we drilled down on her medical marijuana card. It had been expired for about 9 months. So we disciplined, they fired the individual in that regard. But you're going to get some crazy things. Also on the medical marijuana cards, as currently in New York, there is no expiration date on them. They're only good for a year. So you got to look at the date of issuance, and you have to figure it out yourself. Now let's talk a little bit about drug testing issues. The new law that New York passed did us, again, no favors and didn't specifically come out and say certain things. So like New York City has on the books a local law that says, dear employers, unless you fall into these exceptions, you cannot do pre-employment drug testing for THC. We were expecting something like that. We think the law at least implies it. And by that we mean, because we're not going to be able to, a drug test does not prove that the employee who was at work was under the influence at the time. It simply proves that at some point in the past, and depending on how you test, that the individual used, and we cannot discipline solely for use. The same is going to be true pre-employment. So we're advising, unless you fall into one of the exceptions, that Chris went through, do not test for THC. Unless you fall into those exceptions, simply do not do it in that regard. And in a bit, we're going to talk about the specific articulable symptoms. Employers sometimes don't have a grasp of drug testing. And so we wanted to put in here some slides in that regard. Again, not specifically addressed. The recreational activity law amendments that Chris went through call into question seriously whether you should test for THC. We have reasons you should not. The exceptions which Chris went through still apply, and we believe you need to take a strong look at all policies, be it in your handbook or otherwise. Code of conduct, drug testing policies, drug-free workplace statements at this time to make sure you're not violating the law. The other thing that in deciding, let's say you're going to test, employers sometimes don't think it through. Yeah, give me a drug testing policy, a plan. Lab selection becomes critical in this area. Is the lab, which almost all do, supplying a medical review officer to review the findings in that regard? Make sure you understand how the medical review officer operates. They should operate this way. So I can have a legal prescription for amphetamines, but amphetamines will hit on a drug test. When that occurs, the medical review officer should pick up the phone and call the individual. You have a positive hit for amphetamines. Do you have a prescription in that regard? Yes, I do. Send it over. And then what should happen is the employee will pass the drug test, and you should not know that they have a prescription for amphetamines. Make sure you understand how the process will work with your drug testing facility. If you have the pleasure of having a union in the workplace, drug and alcohol testing need to be negotiated in that regard. So make sure to the extent you want it and you're not mandated to do it, or even if you are mandated to do it, there may be portions of the law or regs that can be negotiated. What are you testing for? And this comes up quite a bit. Sometimes employers send employees for confirmatory drug tests. What are you on? I was smoking a joint. No, they weren't. They think they were smoking a joint, but they were smoking something else. Why? Their drug dealer lied to them. Shocking in that regard. Don't rely on the individual who you want to test for what they were on. And if the individual admits that they were using in that regard, do I really need to test them? And we'll walk through the reasonable suspicion checklist. My vote is no, because it's possible, depending on what you're testing for, that test is going to come back negative, and they might be then a perceived drug user, which Chris and I will go over when we go through the ADA section and have protections in that regard. So focus more on the conduct. What levels are you testing for? Not all testing facilities use the same level. So if you're testing for cocaine, it is possible, depending on the sensitivity of the test, that one facility, the person would fail, and another facility, they would pass. So make sure you understand the levels that are being tested for, and make sure you understand the method. Is it saliva? Is it hair? Is it urine? Is it blood? And depending on what you're testing for, it will make a difference how far back, what method you are using, and what you're testing for, how far back it will pick up in that regard. So make sure you understand the method in that. So a 5-panel screen, and the drug testing company may say, what do you want? Well, here's your options. The 5-panel screen, we're going to recommend that you stop THC testing unless you fall into one of the exceptions. You see it also has cocaine, PCP, opiates, and amphetamines in that regard. Your typical DOT test, by the way, is a 5-panel. Plus, they also screen for something called semi-synthetics, which there's a long list of on the DOT website. That is more of a DOT panel that I would call it. It's more of a custom in that regard. If you want the 10 panel, here's Quaaludes, methadone, barbiturates are added. And if you go all the way to the 15 panel, you get tramadol, MDM, oxycodone, and some other lovely substances in that regard. Why not do a 15 panel? It costs more, folks. And if you're going to do a 15 panel for everyone, make sure you realize what the costs are and the cost difference in that regard. We also, in the hiring process, don't drug test everyone that's simply an applicant. I'd make sure you want to hire them first, give a conditional offer of employment, and then do your drug test. And tell them up front, we're doing a drug test. And if so, if you want to walk away. We don't test for pot. I have some employers, even before this law came down, they said, oh, I don't want a drug test. I'd lose half my workforce. And there could be some truth to that. So make sure you understand some of the semantics of the test. Just don't implement something for the sake of implementing that. So with that, I'll turn it back to Chris. We'll both talk about some of the ADA issues that come up in this area. And remember, the ADA is your friend. It is not your enemy in this area. Chris?
Thanks, Mike. So we're going to talk about what the ADA allows, what the ADA doesn't allow, and some misconceptions that are out there. I'm going to talk about notions of illegal drug use versus what we're talking about here, legal drug use with marijuana. I'm going to also talk about the notion of current use. Mike will pick up on that a little bit, and then he's going to talk about efforts to maintain a drug-free workforce and again, getting back to some drug testing issues that are covered by the ADA. So, first and foremost, the ADA, just again, misconception that I'll say it, and some of you may understand this, some of you don't. An individual with a disability does not include somebody who is currently engaging in the illegal use of drugs. Somebody who is engaged in the illegal use of drugs is not covered by the ADA. Well, he's a drug addict. Well, not as far as the ADA is concerned. There's got to be certain things that occur before an individual becomes covered by the ADA. The ADA also, it specifically permits employers to take measures to ensure a workplace that's free from illegal drugs and is compliant with other federal laws and regulations regarding drug use. That's okay under the ADA. But by the same time, the ADA does provide some limited protections from discrimination from recovering drug addicts and people that aren't recovering drug addicts because they say so. It's recovering drug addicts because they were part of a program, they were specifically diagnosed, or they somehow otherwise received treatment for a drug addiction issue by a certified medical professional. So ADA and drugs. Of course, you can prohibit the illegal use of drugs at the workplace. It's not a violation of the ADA to give tests for the illegal use of drugs. You can also discharge and deny employment to somebody who is engaged in the illegal use of drugs. We use some examples of, Mike talked about people who might test positive for one drug or another on a screen, and then they are subsequently able to demonstrate that they've got a current, as opposed to the expired from the receptionist Mike talked about, but a current prescription for what the amphetamine or whatever that drug may be. That's legal. It's not the illegal drug that somebody's got the leftover expired, their parents' expired opioid, and they're using that to manage in the morning, and they test positive for that. That's illegal use. So, and it also is the fact that employees who use drugs, they're going to be required to meet the same standards of performance and conduct that are set for other employees. There may be some exceptions, for people that are in approved programs where it's legal use of drugs like methadone treatment, or somebody who is receiving cancer treatment, that may be different, and there may be some reasonable accommodations which ease some standards of performance and conduct, and those are all done on a case-by-case basis. But other than that, people who use drugs, they're going to be required to meet the same standards as everybody else. You got to know what your requirements are too, as it relates to the Drug-Free Workplace Act. If we're going to hang our hat on that and say we want a drug-free workplace and it's going to affect this entire population of employees, let's know what the rules and requirements are under that act as it relates to your population of employees, to make sure that we can make sure that we are abiding by those requirements, so that that's an adequate approved basis under the ADA. However, notwithstanding all of those things that the ADA does allow in terms of maintaining a drug-free workplace and making it okay to establish policies and discipline and discharge where necessary, there are some protections under the ADA. So it does protect individuals who have successfully completed a drug rehab program, or who are otherwise rehabilitated successfully and they are no longer engaging in illegal drug use. So somebody who previously went to drug rehab, but they're still using cocaine and buying it from their dealer on the street, that's not necessarily covered under the ADA. Again, case-by-case basis, got to be careful, but that's not covered. In addition, the ADA covers individuals participating in a supervised rehab program and they're no longer using the illegal drugs. And then what Mike mentioned before is that the perceived drug user, the regarded as, which is a great category under the ADA. So it's not only the example Mike used when we was talking about drug testing, but it's the individual who you think is the, because of the individual's appearance or behavior, you assume they are somebody who's a drug user. They've never tested positive. There's no evidence that they've ever, used a drug, but you think they are somebody who's a drug user, an illegal drug user, and you terminate them because of that. That person may have some protections under the ADA because you have regarded them as being an illegal drug user. Maybe you also think, well, this person, I think I heard that they went to rehab back in the day. I don't really want anybody like that working around here. And it turns out to be erroneous. Guess what? They're also going to have protection. So always be careful of the regarded as. So an employer can discharge current illegal users of drugs on the basis that such drug use, without fear of being held liable for disability or discrimination. So again, if it's illegal drug use, that's okay. Not legal drug use, illegal drug use. Current illegal users of drugs are not people with disabilities under the ADA. That's an important distinction to remember. If you are illegally using a drug, you don't get a pass if you fail the drug screen and you don't have a good explanation. You don't get a pass if during a locker search, somebody finds an ounce of cocaine in your locker. You don't get a pass if you're found, if you're a former drug, you went through drug rehab previously and you're dealing at the plant. It doesn't work that way. That's not covered under the ADA. So again, it's possession, it's distribution, as well as use. And it also includes the illegal use of prescription drugs that are considered controlled substances. Mike talked about this example of amphetamines previously. Somebody might be using amphetamines for a legitimate medical reason, and there's plenty more that aren't, because they use the amphetamines to get high, they use the amphetamines to manage, and it's not their prescription, or it's an expired prescription, or they stole it from somebody, or they got it from their dealer. They're controlled substances, they're covered, and if it's legal use, that's one thing. If it's illegal use, it's not covered by the ADA, and that's something that you can discipline and you can discharge as a result of that and not be subject to liability under the ADA. Just because there is a prescription, it's got to be their prescription, or just because there's a prescription, sometimes prescriptions have specific sunsets and, don't take it after this date. If somebody's got a prescription, whether it's theirs or somebody else's, and it's either expired or it's somebody else's, that's also not covered. Common sense, but we want to say these things out loud. So the illegal use of drugs, it also does not include drugs that are taken under the supervision of a licensed healthcare professional. And examples include experimental drugs for age, people who have epilepsy or mental illness. If these people are using controlled substances and it's under a healthcare professional supervision, that's okay. That's covered. That's not illegal use. So, and again, just more examples, but somebody is using morphine because of cancer, that's okay. Somebody who's in methadone treatment, and it's supervised by the methadone clinic or by somebody's personal physician, though that's not considered illegal use of controlled substances or drugs. However, let's say you've got somebody, an employee who's epileptic, and that person uses morphine. Let's just use or some other drug that's illegal, and they use it for the purpose of managing the epilepsy. The illegal use of the drug, if it's done without the supervision of a medical professional, not pursuant to a prescription, but it's the individual with epilepsy who's self-medicating, that's not covered. That's illegal drug use. The epilepsy is covered, and you can't terminate them or discipline them because of the epilepsy. But as it relates to the drug use that they're self-medicating and doing themselves without the supervision or of a doctor or without a prescription, that's not covered. That's not something that's considered illegal drug use, and discipline and discharge can occur. So let's talk about current drug use as well. And this is an important issue to just remember. So if you've got an employee who's subject to a drug testing policy and they test positive for the illegal use of drugs, then the individual will be considered a current drug user under the ADA, where the test correctly indicates that the individual is engaging in the illegal use of a controlled substance. So look, we bolded and underlined correctly because, unfortunately, with these drug tests, you get false positives sometimes, right? So if it's not a false positive, if it's a correct indication of, yep, they were using drugs, they're currently engaged in the illegal use of a controlled substance or a drug. So current drug use means that occurred, recently enough to justify you as the employer making the reasonable belief that involvement with drugs is something that's ongoing. That this isn't something that's been in my system for months or years. It's occurred within the last several days, several weeks. It's a case-by-case basis, but that current drug use, if it's done correctly and there's not a snafu with a testing facility, means that you can reasonably infer there's an issue here in the absence of a reasonable explanation, a prescription, the proof of somebody using it pursuant to medical supervision, whatever the case may be. So, and a lot of times what happens too, and I've seen this specifically before, you've got an employee who tests positive for cocaine. That employee immediately checks into drug rehab, and they've got no previous record of being diagnosed as somebody who's got a cocaine addiction, who's got no previous record of receiving treatment for cocaine addiction in a rehab facility or otherwise. So they check into rehab and they say, ADA, you can't do anything for me. And the client says to us, the employer says, hey, our hands are tied. This person's a drug user. We don't know. It's not the way it works. You can't, it's not a get out of jail free card to go run into rehab after testing positive because you had a big weekend the last weekend and got way out of hand and you did some things you weren't supposed to be doing. That is not covered. That's a current use of drugs that's not going to be somehow covered, and you can't avoid the possibility of discipline or discharge under that scenario. And again, there's a huge difference between somebody who tests positive for illegal use and somebody who's previously been in rehabilitation. That's a significant distinction. Somebody has a history of being in rehab, and test positive. They're probably going to be treated differently on a case-by-case basis than somebody who's never had any history and they test positive for illegal drug use. So finishing up a couple more slides here. In terms of efforts to prohibit drug use and alcohol use in the workplace, the ADA, they don't prevent it. Of course, they're not going to prevent it. That would be crazy for public policy reasons, for health and safety reasons. It doesn't interfere with programs that employers have for the combat the use of drugs and alcohol in the workplace, whether it's EAP programs or other types of counseling options that are out there, whatever the case may be. That's okay under the ADA. You should be doing those kinds of things. And it specifically provides that an employer can prohibit the use of drugs and alcohol in the workplace. Of course, you can do that. Everything that we've always talked about, again, keep this in mind. Just because marijuana is now legal in the state of New York for adult use, it doesn't mean that people can use it in the workplace. It doesn't mean they can bring it to the workplace. It doesn't mean they can deal it in the workplace. We had an employer ask us several weeks ago, well, now that adult use is legal, if I've got people that go out for a smoke break, do I have to let the people out? Can they go smoke a joint out there? Do I have to let the marijuana smokers go out with everybody else who are smoking cigarettes in smokers jail outside on the patio? And the answer is absolutely not. No, that's not what this law does. It's also not going to be something that's frowned upon or cause you to have exposure to liability under ADA, okay? Because it requires that employees not be under the influence of drugs in the workplace. I mean, that's a requirement that you can always have, and that the ADA specifically provides that you can do. And frankly, as we talked about earlier, it's an exception under the recreational activities law, and what the state says are the exceptions that allow you to discipline, discharge, and refuse to hire. If you've got somebody who's under the influence at work, it doesn't fly. It doesn't fly. Similarly, if you've got somebody who has a prescription medication, they might test positive for it, but it doesn't allow people to come to work, high on whatever the drug is that they may be legitimately being treated for. You can always, testing positive is one thing, but being under the influence is never going to be okay at work under any scenario. So at this point, I'm going to turn it back over to Mike, who's going to take us home from the end, and then we'll get into your questions. Mike?
Okay. So, just one follow-up on what Chris said, under the influence at work. And as we get into the next session, I want the supervisors to document the conduct, and we'll go through that reasonable suspicion checklist. I don't want the supervisors guessing what the person is on. You're free to ask them, but again, don't believe them in that regard. So the ADA required at the end of the day that employees who legally use drugs, you can hold to the same performance standards. It's a nice, simple concept. Chris met that. Don't be afraid to say, hey, you're supposed to be doing 50 widgets an hour. You're only doing 10. Yeah, I smoked a joint this weekend. It really slows me down, and I don't keep up with it. You can focus on the conduct. You're not doing enough widgets and terminate in that regard. It is always okay to discipline for unsatisfactory behavior, absenteeism, tardiness, poor job performance, or accidents caused by illegal drugs at work. We're going to ask you for the documentation. What days were they late? What days were they absent? What is your policy in that regard? Is there anyone worse? Because I'm going to want to know, why aren't you disciplining the one who has a worse record than this one? To the extent you try to treat drug and alcohol, you don't give them as much as a break as you do your favorite employee, that could cause an issue with you. Remember the spectrum. You have great employees on one end and the employees whose guts you hate on the other end, and the bad workers and everyone in between. You have to treat everyone the same, whether you like it or not, at the end of the day. Also, if you get an accident at work and you think it has something to do with drugs or alcohol, make sure you tell your carrier. If you believe the accident was caused solely, that's the key, by drug or alcohol use, the employee may be denied workers' compensation by the Workers' Compensation Board. Tough standard to meet because of the word solely, but please make sure you understand that and alert the carrier. So here's an example. If an employee is often late or does not show up for work because they're a drug user or an addict, can I take action against the conduct? I don't care that you're a drug user or an addict. You were late or you missed work. I document that and I terminate or discipline accordingly. You might violate the ADA if you impose greater sanctions on drug users and alcoholics. That's why we always ask, is there anyone worse? So we're looking for a comparator, and you'll have to explain to us why someone who is worse is not getting the same discipline. Key, consistent enforcement along that spectrum. I don't care if they're your best friend. I don't care if they're your best employee. Be consistent in your enforcement. Sometimes great employees get fired, and you know that just deal with it at the end of the day. If you have poor performance, if you have someone who is late or tardy, the ADA does not require that you discipline them in that regard. You can help them if you want. You can get them into EAP or treatment, but again, that is your decision. If you want to push them towards a program and you have the goods on them to terminate, one of the things we recommend is a last chance agreement. So I just did one this week. The employee went to lunch, came back highly intoxicated. We believed they did exactly what I said. Ask him what he took. He said, I smoked a couple joints on lunch. We didn't want to fire. They wanted to help. We prepared a last chance agreement, and we're holding him to that. The last chance agreement is a legal document. That is something we prepare just so you're aware. It's a glorified written warning, but it has a lot more bells and whistles in it. The ADA, again, does not require that you go down the rehabilitation path with an employee. Chris and I did this presentation yesterday, and someone asked a great question. We had an employee go through treatment for cocaine. How long should we do follow-up testing for? And the answer is 72 months. That is what my consultant says is the relapse period. And she also told me, she said, don't be surprised. He might relapse 2 or 3 times in that 72-month period. So it could be a long haul that you're in for. The statistics on relapse after counseling and after rehabilitation the first time are startling. There's a lot of people that relapse, and sometimes it takes 2 or 3 times to go through it. Just be prepared how far you're willing to go down the path with the employee. And maybe it's far. That's up to you. Great. It's a business decision. The ADA may, however, require consideration of reasonable accommodations for individuals who were using, no longer are, and have rehabilitated, as Chris explained later. I have to go to a meeting every day, every other day. It's like it's a counseling to keep me on the straight and narrow. My work schedule is 9 to 5. I'd like to change my schedule to 8:30 to 4:30 so I can make the 5 o'clock session. I would grant that in a heartbeat as a reasonable accommodation under the ADA and document. So the modified work schedule, again, I just mentioned. There is this direct threat. You have an employee who has been to rehab 3 or 4 times. They just took FEMLA leave again for a serious health condition, the addiction. Can I deny them reemployment? The FEMLA rules are pretty harsh in that regard. You bring them back. And then it becomes a question under the ADA whether they pose this direct threat. And it's a high standard to meet in that regard. These slides sort of summarize for you the direct threat standard. Again, I would focus on the conduct. Statistical information is not enough. There has to be a high probability of substantial harm to others that cannot be reduced or eliminated with a reasonable accommodation. You only get to this, if they've gone through rehab several times. Some examples of accommodations: periodic testing, modifying job duties, increased supervisions. I'd probably say this person is a perfect candidate for a last chance agreement, and if they violate that agreement, they're done. The New York State Division of Human Rights favors last chance agreements. They put it right in their regulations. So keep that in mind. We entitle the document last chance agreement. We have the bells and whistles. They violate it, you fire. They sue us for disability discrimination. Most likely you're going to win if you've documented everything correctly. Again, the direct threat and the high probability of substantial harm, you don't get to that just with statistical information. It's an individualized assessment based on the person in front of you, and you have to prove it in that regard. That's why I like the last chance agreement, because it typically takes away this. The ADA allows you as an employer to conduct tests to detect the illegal use of drugs. I went through your various options. The other thing we'll talk about in a second, there are awesome custom panels, which we will talk about. The ADA also doesn't prohibit, require, or even encourage drug testing. There's 2 types of drug testing: those that are mandatory by law or regulation, and those that you as an employer want to do at the end of the day. Drug tests are not medical exams under the ADA. Those of you that are familiar with the ADA know there are a bunch of medical exam rules that have to be followed. That's why we can do it pre-employment. That's why I don't even need a drug testing policy. I can test for drugs if we suspect it at work. Again, my question always is, why don't you have a drug testing policy that is reasonable suspicion based? And what are we testing for in that regard? Drug testing doesn't have to be job related and consistent with business necessity. Why? It's not a medical exam under the ADA. An employer may refuse to hire an applicant who refuses to take a drug test. I can discipline or discharge an employee who refuses to take a drug test. I can do this even if the applicant or employee claims I just stopped using drugs last week. Same thing. I'm going to test positive, so I'm not going to do the test, but I can still fire for the refusal to take the test. Please remember to comply with all applicable laws relative to drug testing. Also remember the ADA confidentiality requirements relative to the drug testing results. We would put them in the medical file in that regard. And remember the medical file, there's a limited access to that file in that regard. Also, do not forget, I have to produce the medical file to an employee. There is a OSHA regulation that basically allows employees access to their medical file. I'd simply make them a copy and give it to them. I wouldn't show them the original. Again, drug testing, we are recommending stop testing for THC unless those exceptions apply. Sometimes a drug test, remember I explained to you how if someone tests positive for amphetamines, how it should work. Make sure that that is the process. Sometimes I have been told, I haven't seen this, the drug test would come back, yeah, he failed for amphetamines, but he had a prescription. So he's passing. I hope that doesn't happen, but then you really can't hold that test against them. So that's why it's critical that you make sure you understand how the results will be communicated by the MRO. We recommend that drug testing be part of a conditional offer of employment. You don't do it unless this is a candidate you want to hire. Otherwise, drug testing is going to get very expensive. We saw one employer doing it for every single employee, every single applicant before they even made the decision where they're going to hire them. And the CEO called me because he was in the store one day and he saw this going on. He's like, "Why are you sending this person for a drug test? We haven't hired them yet. And oh, we thought we had to do it for everyone. No, I just keep your costs down. Only do it for candidates you give a conditional offer of employment to. If you give the conditional offer of employment, they test positive for cocaine, you're free to withdraw the offer of employment." Let's see, most of this stuff I have mentioned already. Okay, so let's talk about employee handbook and supervisory training. I want you to go through your handbook and be guided by these general principles. We're happy to help to fix the things in it. You want to implement clear, well-defined policies, no overreaching. I don't care if the employee drinks Pepsi or Coca-Cola outside of work, unless maybe you work for Coca-Cola. So make sure clearly defined, well-defined, clear policies. You want the employee to sign off on the policy. The more sign-offs, the merrier. I am a fan of the redistribution of the employee handbook every single year. In your handbook, you should only go so far as to protect your legitimate business interest. I also want decision-making done by individuals who are trained. So if we're going to talk about the reasonable suspicion checklist, has the supervisor gone through the training in that regard? And when you do our training, it's almost a whole day long on this issue. So let's say you have a policy, only the head of HR can make the final determination on reasonable accommodations. What that means is I don't want frontline supervisors doing that. And make sure your supervisors are trained that if Johnny comes to you requesting a reasonable accommodation based on a disability, that they goes to the head of HR. We recently had a case that's exactly what all the rules said. The the supervisor who got the request violated the employee handbook, decided to handle the reasonable accommodation request, denied the reasonable accommodation request, fired the individual. The individual files a claim for disability discrimination. We defend it, and we quickly realized there is no defense. And so we had to settle up with the former employee. We hired the former employee back, and then we disciplined the supervisor, did not fire, for being an idiot and ignoring our policies and procedures. Make centralized, trained individuals will become very important in this area. Personal data should be stored safely. In this particular area, it's the medical information in the medical file. Please remember, you also have an obligation as employers to protect personal identifying information, social security numbers, dates of birth, things like that. Apply training to employees regarding the appropriate use of IT. You know, one of the workplace rules we're going to recommend to you is you cannot order cannabis online. Once the dispensaries go active, they're all going to have websites, and you're going to be allowed, I believe, to pre-order THC products online for pickup in the store. Chris mentioned the Lee, Massachusetts dispensary, which I think is the closest dispensary to us. You know, I took a look at their website. It's there. You can You can pre-order and you can pick up. You can prohibit that conduct. Say, you can't use our computer system to do that. Always document discipline issues. We're going to ask you for the documentation. Please remember, if it's not in writing, it did not occur. That is not only Chris's rule, my rule, every employment attorney in our firm. That's the rule of the EEOC and the Division of Human Rights. They won't admit it, but that's the rule they will hold you to. Do not overreact to what you see, what you hear, what you learn in your capacity as a supervisor, but don't underreact in that regard. Don't automatically jump to discipline in this area. Here, we're going to show you a couple slides why. Is this a good reason to fire someone? They post this on their Facebook page outside of work, not working, and you look at it and you discover it. What's the first thing you think it is? My God, that's 4 lines of cocaine, and he's about to snort it. We're going to fire that person, right? No, I'm going to have a discussion with him first. What the heck is this? And maybe he's going to say it's flour or sugar, or it's a joke in that regard. Sometimes all you have to do is talk to an employee and say, maybe you should use some better judgment. You don't have to discipline. Many employers overlook that management tool. I think it's a powerful management tool because you really don't know what you're looking at. You'll jump to a conclusion. How about this? Some things to always ask. Did you post it? Why did you post it? Why? Explain why you think it's a problem for the employee in that regard. I am a firm believer in confronting and asking questions. We recently had an employee who services many consumers. Many of the consumers that she services are African American, and there was a photo of her on her Facebook page with a Nazi flag behind her, and they confronted. They went through everything. I'm not quite sure I believed what she said, but she basically took the photo down, apologized, said she was at a bar where it was up. She didn't even realize the swastika was there, but she made it her profile picture. And I said, I don't know about that. So, but they believed her, and they took care of it with no discipline. If you Google my name, all right, so if it's on the internet, it must be true. Nah, come on. If you Google my name, this is going to come up. It's a mugshot of another Michael Schiotti. You're going to get those news articles with employees that come up. Make sure it's your employee. I just got a call from a client yesterday saying, yeah, and I said, first question, there's a newspaper article on this person. I said, are you sure it's the right person? And they're like, yeah, they used the person's address. I said, okay, but don't jump to conclusion. Just because it's on the internet does not mean it's true. I pulled this mugshot off of a website called mugshots.com. It's a different Michael Schiotti, and I put up there the year he was booked. And it's an entertaining website if you have nothing else to do. Take a look at your code of conduct. What provisions address illegal drugs? Are we going to modify them? Make sure it addresses other prescription medication. Just because it's a prescription med doesn't mean you should be using it. If it's someone else's, it's illegal to use. And if it's a prescription med, I like putting in place the following rule, which I believe is legal. If you are taking any prescription medication that impacts your ability to safely perform the essential functions of the job, please tell us so we can figure out what you can and can't do. I believe that rule is legal. Compare it to the following rule, which I have seen some employers enact. Please tell us if you're on any prescription medications. That rule is illegal. That gives you Viagra. That gives you birth control. That gives you cancer medications that they're not entitled to know anything about unless you affirmatively ask for some type of reasonable accommodation. Take a look at your alcohol rules. Do you have everything covered? Take a look at your anti-smoking rules. Make sure it covers vaping and e-cigarettes and things like that. Take time, go a little broader than THC. And the purpose of today is to think a little broader, not just about THC, but drugs, alcohol, code of conduct, things like that, that now may be the time to reevaluate. Some things that we suggest you take a look at adding. No employee can possess marijuana at work, including in a personal vehicle parked on company property. You cannot be under the influence of marijuana while working. You cannot use marijuana while working. You can't possess, sell, use, etc., drug paraphernalia during work hours. You can't sell marijuana while working. You can't auction off marijuana. We actually had this come up, and it just brings a smile to my face every time I recount the employer calling me. The employee had a legal medical marijuana card, brought the medical marijuana to work, and then decided to auction it off while at work. I was pretty sure it was a felony, but we just fired the guy for being an idiot, possessing a medical marijuana at work and trying to sell it, auction it at work. Can't barter marijuana while at work. You can't possess drug magazines while at work. Go to Borders. There are all these magazines, THC Today, Cannabis Weekly. These are real magazines. You can ban them just like you can ban Playboy, Penthouse, and things like that. Hygiene rules. You can't come to work smelling of marijuana, smelling of smoke. I believe those are appropriate rules for you to enact. Search rules. Do I have the right to search your desk in that regard? Absolutely. Your locker? Absolutely. How about an employee's purse or their personal vehicle parked on company property? You have the right to ask. If the employee refuses, you can discipline for not cooperating with an investigation. I had one employer recently, a healthcare facility, thought one of their employees was drunker than a skunk. And I said, go ask her and then do a search of her area. And she took out a bottle of whiskey, which only had a little bit left out of her purse. They proceeded to immediately fire her. So think about the search rules in that regard. And make sure if you have the pleasure of having a union, you try to negotiate some rules with the union. If you have individuals with employment contracts, make sure that you hold them to your code of conduct. Drug testing considerations. If you, I'm a fan of reasonable suspicion testing, which we'll go through in a second. Or do you want to use a 5, 10, or 15 panel? We recommend the exclusion of THC unless the exception applies. There are things called a custom panel. Believe it or not, there are substances out there, synthetic drugs and other drugs, that won't hit on a 15-panel drug test. You have to do what is called a custom panel. So one time, one of my clients had a group they thought were higher than kites at work, but they came to me late in the process and they kept passing a 15-panel drug test. And we came to the conclusion, I said, maybe we should start looking at their emails in this regard. So they started monitoring the employees' emails. One of the employees slipped up, said what they were on. It was not covered by a 15-panel. We contacted my drug testing consultant. We lined up a custom test for the substance that they were using. It was some type of leaf imported from the Orient, which if you ground up and snort, gets you basically highly intoxicated at work. Their policy had like a catch-all that said any other substance that gives the impact of a controlled substance. We tested them. They all failed. We fired the whole bunch of them. Make sure you realize the method that you're testing and how far back. Always remember, if they admit to using, I really question whether you should test. I think that's enough. Remember the documentation we've been talking about. Sometimes you as employers overlook your smartphone. This is a powerful device. It can record audio. It can record video. If you have an employee sleeping, take a picture of them sleeping. Take a video of them sleeping. Let it run for a few minutes, and then wake the employee up and video the employee waking up. That's your documentation. It's wonderful documentation in that regard. Consider that, make sure you understand how your lab tests and how far back they're going to be able to grab these substances for, because that's going to dictate how quick you do the test. And my rule of thumb is the quicker, the better. Also figure out how they're going to get there. Don't let them drive if you believe they're impaired. Don't let them use a taxi. I would have a manager drive them there and bring them home. If they refuse, you don't force them in the car. Other things in that regard. We discipline for not doing the test. I forgot on the search rules, if they say, no, you're not going to look in my purse, don't look in their purse, just discipline them for not allowing you to look in their purse or their car, and you can terminate in that regard. Be mindful of what you see on social media, especially now with the amendments to the recreational activities law. We believe if you have a drug-free workplace, you have to modify your drug-free workplace statement in that regard. We highly recommend supervisory training. We'll go through the reasonable suspicion checklist in a second. We want the supervisors trained on ADA protections. We want the supervisors trained on confronting and asking questions of the employee and how they do it. So instance, I mean, always ask, are you high? What are you on? Where did you get it? Now, there's also another approach that depending on if you think you have a bigger problem, have a supervisor buddy with the person. Hey, what are you on? Looks pretty good. You got any more? Can I buy some off you? That's being a good supervisor. And all of a sudden the employee opens up to you. Oh, you entrapped me. There's no entrapment. And sometimes you could have a huge issue. So don't be afraid to contact law enforcement for guidance. One time law enforcement planted an employee and they busted a huge drug ring that was operating out of a facility, and dozens and dozens of arrests. So supervisory training becomes important. These recognition of specific articulable symptoms. Right now we don't know what that means. I think I know what it means. Chris thinks he knows what it means, but the state of New York may give us guidance to the contrary. So right now we have this reasonable suspicion checklist. I just want to go through it with you. I believe that this is your documentation of specific articulable symptoms. And when you go through the form, and you should hopefully have it printed out. If not, I'm just going to walk you through it. Part 1, employee information, the employee name, their job title, what date did you observe this, time and location. Remember, who, what, when, where, why, and how. That is the key to the documentation of discipline. Observations, what did you as a supervisor observe? Now, if you have 2 supervisors completing this form, make sure you're all on the same page in that regard. Maybe just have one of you complete the form and both of you talk amongst themselves and you'll both sign off. So the observation parts is physical, behavioral, and miscellaneous. Under physical, and sometimes you'll go through this and we can sort of explain why these things are there. Walking, standing, movements, eyes, face, breath, speech, appearance. One of the things we like to show during supervisory training are videos which show examples of what individuals are on. Remember, I don't want you to try to figure out what they're on. You can ask them, but we're more interested in documenting this conduct. Behavioral, what is their demeanor? What is their actions? What is their appetite? They may have the munchies and they'll eat whatever's in front of them. We're observing that and writing it down. Miscellaneous, is there drugs or alcohol in the vicinity of the employee or on their possession? Was there any misconduct involved as well? Maybe the employee started a fight. Remember, I can independently discipline for the fight. Employee admission to drug or alcohol use. Yeah, write it down. And if you're smart, you have your smartphone out and you're videoing them. Are there corroborating witnesses? Make sure you write them down and what you think they can corroborate, maybe get statements from them. Are there other observations that we didn't have on the checklist? If yes, write it down. I always give the employee the opportunity to respond. Sometimes it's extremely entertaining. You can either write down the employee's explanations or maybe on a separate piece of paper, ask them to write down their response in that regard. And part 4, the action plan. Are we going to test? Maybe the employee has refused to test. Are we going to refer to EAP? Are we going to go with a last chance agreement? Are we going to terminate the employee, and document and then appropriate signatures? And if you can get the employee to sign, that's great. Remember the employee, sometimes I tell the supervisors, ask the employee to write refuse to sign. Sometimes they do. And that's an acknowledgement from them, and then have the supervisor know, I asked him he refused to sign, so I asked him to write refuse to sign. That's his signature, Johnny Jones, supervisor. Great supervisor, but I'm hopeful you really will do the supervisory training. Also think about law enforcement. Do I call the cops? First, realize it's okay if you're wrong, but if you seize illegal drugs from the employee, what are you going to do with them? Some rules of thumb: do not place in the personnel folder because you're in possession of a controlled substance. Do not give it back to the employee. Do not dispose of it. Why? Where's your proof? Do not use it or sell it. Really, I did have a supervisor ask me that once. Can I use it? Can I sell it? No. I don't mean to make light, but even some supervisors need a reality check in this area. If I call law enforcement, someone might get arrested. Oh, well, I have had many law enforcement officials come into court or hearings to testify on behalf of the employers. Hopefully, they're very impressive. And so far, I've batted 1,000 in that regard and have had nothing but good luck with law enforcement being my witness. Remember, discipline. You don't have to terminate. You can do a verbal warning, written warning. You can do a last chance agreement. The last chance agreement contains a release of claims. You can put follow-up testing requirements in there. Make sure you review your requirements under FEMLA, ADA, and the human rights law. What are your conduct expectations of the employee? Is there counseling and treatment? Are you going to request access to the medical notes? Who's going to pay for the treatment? There's lots of things that go there. Termination of employment, the documentation, the videos all become important. We'd ask you to stay tuned. There's more to come from the state in this regard. And again, I think Chris and I are going to be doing another one of these programs on the DOT side of this, just to sort of fill in the other part and some of the exceptions. So with that, I'm going to take a look at our questions. And you can put your questions in the chat in that regard. Okay, so the first question: the contracts that we have with the counties require us to have a drug-free workplace policy because they receive federal funding. How will this affect us? Teresa, it will depend upon the exact language in the contracts and what they are requiring. They may simply be requiring that you have in place a drug-free workplace statement as opposed to testing in that regard. And if you are deemed a federal subcontractor and the federal government is imposing drug testing requirements on the county and they're imposing those requirements on you as a subcontractor, we think that's probably going to be okay. Chris, anything you want to add?
No, I agree.
Okay.
I agree with that.
All right, so next question. Let's see. Would the reasonable suspicion checklist be considered an attachment for fitness for duty? I'm not sure what you're getting at, Karen. We use this as a guide to document employees' behavioral issues while at work, what we are observing. We think they're on something. So one of the examples I like to do is the employee's on a forklift, driving too fast, took a turn too fast, and a supervisor heard him saying, "wee," as he was going around the corner. get him off the forklift. You don't have to wait for him to hurt himself or others or damage property. And then let's run the checklist with him and go through it. So it's more focused on conduct. I think I need to know more about what you're thinking in that regard. Chris, any other thoughts?
No, I don't. I mean, frankly, I don't think that checklist is something that you necessarily want to publish or have as be a part of policy. I would just keep that and use it as a guideline. I don't think it's something that should be broadcast.
So someone said to me, can I provide the link to the decision tree? Absolutely, Christina, just email me and I will send it to you. And then the question, I'm not quite sure. What about blood tests for THC? Well, the rule's the same. We're recommending don't do drug tests for THC unless you fall into the exceptions. There are 4 methods of testing for drugs, blood. We can do saliva, we can do hair, we can do urine. Each, costs different. Each has their own set of rules attached to them. So, blood testing for THC is I would say is don't do it unless you fall in the exception. Chris, anything to add?
No, I agree with all of that.
Is the reasonable suspicion checklist enough to terminate for job safety reasons? Can the checklist be used to immediately test for THC and then terminate? Can testing for THC and alcohol be acceptable as a result of a workplace injury, damage to property? Well, let's take them one at a time. Is the reasonable suspicion checklist enough to terminate for job safety reasons? Let's take a step back. You're using the checklist because something has happened. You have observed something, someone has told you Johnny is acting crazy, and we go down the path of that. We're documenting conduct. And if you believe, based after completing the checklist, yeah, he's on something, I believe that is enough to terminate. You're terminating based on conduct, based on observation in that regard. Chris, anything you'd like?
No, I agree. Remember, that the reasonable suspicion checklist helps you qualify for the exception, the impairment exception, right? It's that term that is not defined by the MRTA, right? So if you can objectively, if you go through the checklist and it's there and it's documented and there's no reaches and it's clear this person is impaired, yeah, I think that's fine. You can terminate somebody in that regard, and you're not going to run afoul of, to the extent that the use took place prior to the start of a shift, you'll be fine.
Can the checklist be used to immediately test for THC and then terminate? Remember, unless you fall into the exception, we're advising not to test for THC. And the checklist, I think there's 2 things that could flow out of it. Has the employee admitted to drug or alcohol use? Has the employee admitted that they are intoxicated on some substance while at work? Do they have in their possession illegal drugs or even THC and cannabis? They violate the workplace rules. I don't have to send them for a test. I can discipline. But if you suspect that they are under the influence and you don't have that other stuff, yeah, I think you use that as a basis to go get a drug test. But again, the THC part of it, I don't like, and we don't think you should test for. Now, the statute doesn't say you can't test for THC, but it does say I can't discriminate against someone because of the legal recreational use outside of work. We don't know, are they inebriated or intoxicated on THC right then and there? Chris, what do you think?
No, I agree. I think if you go through the checklist and you're able to establish the objective conditions that we talked about, right? You don't need a test. That's you've got enough there to be able to discipline or discharge, whatever you want to do. And remember about the test, we've talked about this before. If you've got a number of the different checklist boxes checked, right? The test doesn't do anything for you because it's not in real time. It's not like a breathalyzer. Until we get that technology, all it shows you is that somebody was high at some point prior to when they took it. It could have been a week ago, it could have been a month ago. But if you've got those objective criteria that exist, that's enough. It's an exception. You can do what you need to do.
Last part of the question, can testing for THC and alcohol be acceptable as a result of a work accident, injury, or damage to property? Well, let's start with, again, our rule. We don't like the testing unless you have one of the exceptions at play. OSHA does have a rule on drug testing. You cannot automatically drug and alcohol test an employee where there is a workplace accident. They want you to have a little more. So for instance, and also remember, even though we're not really specifically going over alcohol, we've mentioned it time and time again today, a breathalyzer is a medical exam under the ADA. So another set of rules flow. I'm going to have to prove it's job related and consistent with business necessity. So Johnny gets hurt on the job and there's an empty bottle of scotch next to him and I smell alcohol. Is that enough? Have I meet that job related and consistent with business necessity? I think you have in that regard. So it's always a little more that I take the position we need. And let's go through the reasonable suspicion checklist. Do you have reasonable suspicion? And sometimes if the accident is so severe, you're not going to be able to complete it. 911 is called and you're going to have an ambulance personnel there. EMTs are going to be there taking care. I mean, to the extent you can you're at your place, I sometimes tell employers, listen, see what you can hear the employee say, and then complete the reasonable suspicion checklist. We had this come up with a COVID issue. The employee had been certifying every single day, I'm fine, I'm fine, I'm fine. And then one day at work, they collapsed. Turns out they had COVID, and they have been lying on the daily forms. They had been sick, and they admitted to the EMT, and the employer supervisor heard it. Yeah, I've been sick for several days in that regard. I think I might have COVID, but they kept coming to work. Listen in that regard. Chris, anything you want to add?
No, I think I agree with all of that.
Do you feel that we should update our employee handbook now, get acknowledgements signed, or wait to redistribute at the beginning of the year with all other changes? Lisa, I think what you should do is begin the review of policies, begin the review of the employee handbook. We don't know when or if we're going to see these regulations from the state of New York. It could be at least 6 months, if not longer, maybe shorter, who knows? But I think you should begin the process now, because some of the things we have went over here today, such as the walking around and possessing, are real, and they go into effect immediately. So I would at least begin the process now. I think the redistribution, if in 3 months we decide to redistribute based on the changes we've made, let's do it. I guess, but what I don't know is, are we talking a couple dozen employees or a few thousand employees? I think that might make a difference to me. Chris, anything you'd like to add?
No, agree. I agree.
Okay, in regards to tobacco policy, Southern Tier Tobacco Awareness Coalition provides free support and signage to employers looking to update their tobacco vaping policies. And for more information, you can reach out to the Chemung County and they will give it to you. So that was a plug. I don't mind plugs in that regard. That's the last of our questions. Does anyone else have a question? You can put it in the chat box. Otherwise, Chris and I are going to sign off. Just some concluding remarks from me, and then I'll let Chris wrap it up. Take a look at your policies. Let's do some training. If you have federal contracts, federal grants, let's get a hold of them so we can see what your requirements are. Chris?
Yeah, as I mentioned, things are changing. We're going to see some additional rules and regs, and as they come out, Mike and I will make sure that everybody is informed. We'll also let the chamber know about, our next presentation where we drill down on some of the issues in respect to federal requirements and funding and the like. And again, if you've got questions, please let us know. We're happy to help, but thanks for tuning in today.
Take care, everyone. And with that, Candace or whoever's on, I will turn it back over to you.
Thank you, guys. Thank you, Michael. Thank you, Chris. You both did a great job on this presentation. We will have the recording uploaded shortly. And again, I'll send that off to everyone who registered today. It will also be available on the Chamber's COVID resource page. If you have not been to that page, there's lots of information there. Anyone who's on that's not a chamber member, if you're interested in membership, you can reach us at 607-734-5137 or shoot us an email at info@chemungchamber.org. Thanks for joining, everyone. Have a good day.
Thanks, everyone.
Take care, everyone.